Thank you for joining me today on the topic of considering children's wishes in the family court. Our firm is a specialist family law firm, and I'm one of 5 accredited specialists in the firm. We only practice in family law. Our firm produces a number of great publications, which I would recommend to you. We do a guidebook which goes through basic family law principles. Michael's been producing that for many years, and it's assisted hundreds of people. We also do a monthly e-flyer which deals with the topical areas, and they are generally short and punchy, so I would commend both those publications to you. Before we launch into the topic, I just want to let you know about there's going to be 2 polling questions where I will ask for some audience participation. That will flash up on your screens, and I just would ask that you answer them how you think. There's no right or wrong answer. It just helps to make things feel a little bit more interactive as we proceed today. So just launching into an overview so we can understand where we're going today. The first thing that I'm going to talk about is what are some of the common mythologies surrounding children's wishes? How do children's wishes fit into the legislative framework? How are children's wishes captured in the family court? The role of an independent children's lawyer and a family report in the context of children's wishes. What weight is applied to children's wishes, and that's very important, as you'll see. And then we talk about relocation in the context of children's wishes, and we talk about some recent decisions that have been handed down in the family law circuit, and it deals with children's wishes. Finally, I just want to end off with what all this really means in practice, and give you some advice and anecdotes and experience from practicing in family law. So going first of all to what are the common mythologies surrounding children's wishes, and there you'll see some examples of statements I would commonly come across in practice. These are sorts of things that clients would come in and say to me on a fairly regular basis, and I'd suggest that you perhaps have similar experiences in your own practices. So just on the next slide, probably the one that I shake my head at the most, and it seems to be fairly widespread practice, I think, is the letting the kids decide. In my view, that's sort of really abrogating parental responsibility, and all too often it puts too much pressure on kids where they feel torn between their parents and not wanting to offend either one, or opposite, it creates kind of this little emperor sort of syndrome where they're deciding things on a whim. So I'm not really advocating that you don't listen to children. I always tell clients that you should listen and listen carefully, but also let them know that at the end of the day it's mum and dad that decide, and that's certainly the court expectation. I've certainly seen judges in my time read the Right Act to parents who dare make the suggestion that it should be up to the children. That brings us to the first polling question, which is, at what age do you think a child can decide where they wish to live or how much time they spend with one parent over the other? So you'll see there on your screen that there's 4 options, 7 to 10, 10 to 13, 14 to 17 or 18. So if you could just take a time to answer that, that'd be great. Okay. Thank you for providing that. You're going to have to wait till the end of the talk to find out the answer, but just keep that in mind as we proceed. Now, the first thing that we're going to look at is, how does children's wishes fit into the legislative framework? I'm just going to try and give you a brief overview. It may be that some of you have already listened to some of our topics before and have a basic understanding of family law. Basically, we've got to look wider than the Family Law Act and what has been influencing the Family Law Act. Look, the Family Law Act deals with human beings in a very real and personal sense. We live in a first world country, so we really have to go to human rights law, and that makes sense. And one of the biggest influences on this particular topic as it relates to the Family Law Act is the Convention on the Right of a Child. We adopted as a country that convention on the 2nd of September 1990, and that's almost 27 years ago now. The children's wishes really is underpinned and reflected in the Family Law Act at Article 12. So if you look at Article 12, which should be the slide on your screen now, it says that parties shall assure to the child who is capable of forming his or her own views the right to express those views freely in all matters affecting the child, the views of the child being given due weight in accordance with age and maturity of the child. For this purpose, the child shall in particular be provided the opportunity, so that's important, provided the opportunity to be heard in any judicial and administrative proceeding affecting the child, either directly or through a representative or an appropriate body. So we've adopted essentially that idea, and you'll see that in our Family Law Act. It's under the Family Law Act, it's the best interest of the child is the paramount principle when a court is considering making parenting orders. And you're probably familiar with that principle. Just moving on then, how does a court decide what is in a child's best interest? So looking at that, they have to consider the primary considerations first. That's the benefit of a child having a meaningful relationship with both parents and the need to protect a child from harm. The need to protect from harm actually takes precedence over the meaningful relationship in the appropriate circumstance. We're not really concentrating on that today. Our concentration is actually in the additional considerations. And the additional considerations after a judge has considered the primary considerations, the first factor that they've got to consider, or the first thing to consider, is any views expressed by the child and any factors such as maturity and understanding that the court thinks are relevant. So just note here that there's no reference here to age of the child. And as you might be aware, you can have a very articulate and well-spoken 10-year-old, and sometimes you can have a very immature and silly 14-year-old, as the case may be. That's all caveated, however, by the fact that a child cannot be forced in family law proceedings to express their wish. And that makes sense if you consider that that really would be a breach of human rights if we were to make children express a view. And that would go against, obviously, what we're trying to achieve. Let's move on to how children's wishes are captured in the family court. So there's 5 main ways that it is captured, with 4 and 5 there being the most common way they're captured in our jurisdiction here in Australia. The first of those is by affidavit evidence of a parent in a case. So this will be usually how parents first get to court, is that there's a dispute that they can't sort out. They have to try mediation, and sometimes that's even child-inclusive mediation, and that's getting ever more popular today. And if that's not successful, they obtain what's known as a Section 60I certificate, which allows them then to commence an application in the family court. Attached to that application is an affidavit, which sets out their story as it relates to the dispute and the facts of their case. And this is usually the first time that the judge or the court will be aware that there might be some issues surrounding wishes of a child. It's important to note that children are not allowed to swear their own affidavit except where they seek to be a party. We're going to talk about that shortly. And likewise, they cannot be called as a witness or even be present during court proceedings. And this is all reflected in legislation. Just as an anecdote, I remember practicing many years ago. I was representing a father of two young boys in court, and the mum was self-represented. She had been represented right up until trial. There were 4 children in this relationship. 2 of them were much older, and the trial was actually about the 2 younger ones. But the eldest daughter in that case had just turned 18 at the date of the trial. Now, it was a really bitter dispute, and it had gone on for a couple of years, and it had lots of complex issues. But Mum, like I'd said, had been represented right up until the trial, but then she'd sacked her lawyers just before trial. And interestingly, she rocked up at trial and she'd filed, to my client's horror, an affidavit by their adult daughter, just remembering she'd just turned 18. And I can remember the judge said that technically she was allowed to, because the child was 18, so an adult, and could swear an affidavit. But he strongly recommended that she not rely on it, and that more than that he would probably draw some adverse interests against her if she did seek to rely on it. So thankfully she heeded his advice and didn't rely on it. But I think that just shows you how much the courts generally frown upon children providing affidavits in their parents' dispute. It just doesn't happen. And even adult children. Probably the only circumstance where you might find that it would be okay is if the parents are sort of much older and it was only involved in property disputes. So if there was a property issue, say one of the adult children were involved in a business and they had some running knowledge, that might be okay. But certainly anything to do with the children and their relationship, that is very, very frowned on, even if the kids are adults and can technically swear an affidavit. The second way is by a judge speaking directly to the child. Now, this is an exceptionally rare practice, which is certainly not encouraged in Australia. There used to be a rule in the family law rules which expressly referred to this practice as an option for the judge, but it was later repealed. So it is still allowed today, but it's no longer expressed in such unequivocal terms. Now, when a judge is looking to meet with a child, the option comes under such other means as the court thinks appropriate. As I said, it's not encouraged in Australia, and in fact Dr. Michelle Finardo, who is a family law lecturer at the University of South Australia, undertook some very interesting research into this topic. Her findings were that it only occurred in 1 to 2 cases per year, and if you think about it, there's hundreds of cases that would come before a family court each year, so this practice is practically non-existent. She wrote an article, which I refer to there in the slides, known as Children's Direct Participation in Proceedings and the Views of Australian Judges. This is a 2013 article, so it's fairly recent. It is based on a presentation she did in July of 2012. And look, I'd highly recommend or commend the article. It's an interesting read and gives a snapshot of judges' views here in Australia compared to their counterparts in the UK and New Zealand. What she was really interested in was whether we are upholding the conventions of the right of a child and the recommendations pronounced in the Seen and Heard inquiry conducted by the Australian Law Reform Commission back in 1997. There were some very interesting interviews, and I'll just take a moment to read to you how the judges in different jurisdictions felt about speaking with children, because I think it really gives, it takes home the point how Australia feels about it, or how Australian judges feel about it. So a district court judge in the United Kingdom said this about interviewing a child. He said, "Shanika's presence did not add to my knowledge of the case, nor did it assist in any decision which was agreed in any event. However, I hope and believe that when she looks back on the awful events which changed the course of her life, she will feel that she was acknowledged and respected by the family justice system." Now, I want you to compare that to an Australian family judge's views on meeting with a child. This is what they said. They said this: "To my mind, The prospect of meeting with a child is just about as scary as handing me a scalpel and saying, "Just a bit of brain surgery before lunch, please, Judge." It almost gets into that realm for me. I'm terrified of it. So that just shows you, I think, that Australian judges practicing in family law or child protection here are all of a fairly similar mindset, whereas judges from other jurisdictions were much more open to the idea of interviewing children and thought it was actually quite helpful. This could be a topic within itself, but I just want to sort of caveat that there are good reasons why judges might not want to meet with a child, and they can include, you know, disclosures being made to a judge, you know, what's influencing the child to say certain things, procedural fairness reasons for parties, and sometimes it's just being a little bit too close. And then having to make a judgment. So there are certainly good legal reasons for not wanting to proceed that way. The third way which can be captured is by an application of a child seeking to become a party. This means that a child of the appropriate age and maturity directly instructs a solicitor to represent them in proceedings. Again, this is an exceptionally rare practice. In fact, I would say that's even more rare than judges actually speaking with children. So whilst the legislation allows for it in theory, it just doesn't happen. I've certainly never seen or heard of it in my 14 odd years of practice. And interestingly, I sort of think it sort of goes against the grain of children not being put in the middle of their parents' dispute. If it is direct representation, then the solicitor who takes the child on is to act on the instructions from the child, and they owe the same duty of confidentiality that they would an adult. So that's really important, I think. So that's what the direct representation model looks like. The solicitor, but this is what's different, the solicitor who the child is seeking to instruct ultimately makes the decision whether or not the child has the ability to form sound and reasoned judgments and understands the consequences of their actions. Look, I would say in regards to that last point, it would be a brave lawyer indeed that would take on a child in family law proceedings. Like I said, it just doesn't happen. This ties in with the appointment of an ICL, which is my next slide, because as I've mentioned here, our focus is on the best interest model. So we're in Australia, we use the best interest model. So the fourth way is by appointment of an independent children's lawyer, or an ICL. They are appointed by the court. ICLs are solicitors who practice in family law who have been approved to practice as ICLs. An ICL is not the children's legal representative and does not act on their instructions. An ICL must act in the best interest of the child, but not necessarily act on the wishes of the child unless those wishes are consistent with their best interest. Now, what you'll find is that children often struggle with this concept of an ICL. They expect, like mum or dad's lawyer, that an ICL is their lawyer and they should represent their views in court. But of course, that's not the case. The ICL is a best interest advocate here. I think it's interesting though that under the best practice guidelines for ICLs, they have to inform a child of the possibility of them being able to instruct their own lawyer by way of direct representation. So there's still that obligation, I guess, or best practice guideline that the ICL should be telling a child about that. The final way, and I would say the most popular way of capturing children's wishes in Australia, is by way of a family report. It's appointed by the court, so a family consultant does the family report, and the family consultant is appointed by the court or arranged by an ICL. Family consultants are approved by the court and are psychologists or social workers who specialise in child and family issues after separation or divorce. We're going to spend a little bit of extra time on ICLs and family reports because this is really the preferred method here in Australia to capture children's issues. So if we look at the role of an ICL, an ICL must ensure that any views expressed by a child are fully put before the court in an admissible form. So they can't just sort of stand up at the bar table and say, this is what the child said. They have to provide it in an admissible form, which is through a family consultant, through a report, through some sort of expert evidence. Pursuant to the best practice guidelines for ICLs, a child has a right to establish a professional relationship with an ICL, and there is an expectation that an ICL will meet with a child if they are of the appropriate age and maturity. That's again in the best practice guidelines. You'll recall that I said that in becoming an ICL, you have to first be approved to be on a panel. Here in Queensland, the ICL panel is run through Legal Aid, and part of those requirements are that you have to participate and successfully complete a 3-day workshop on the role of an ICL, essentially. I haven't applied to be an ICL, but I did participate in the 3-day workshop run by Legal Aid Queensland back in late 2015. And what I found very interesting was the number of ICLs in Queensland who routinely didn't meet with children at all. I was speaking with one very senior ICL practitioner who'd been an ICL for many years, and she told me that certainly a lot of her colleagues didn't meet at all with the children, but she did try to meet with them, but she'd only meet with them once, and it was always at the beginning of the matter, and it was always with a family consultant present. So it seemed to me that ICLs almost had a similar view on meeting children as judges do. So that sort of is just an interesting point. Apparently in New South Wales and other jurisdictions, it is much more common for ICLs to meet with children more regularly. An ICL, in considering any wishes expressed by a child and the steps to be taken in a matter, is to be aware that each child will have a different emotional, cognitive and intellectual development, family dynamic and structure, sibling relationship, religious and cultural background, and that they are vulnerable to external pressures when caught in disputes involving their parents. This goes back obviously to the idea that children are being pulled in all sorts of directions and that they just could be vulnerable, and you have to be aware of that. The important thing is that an ICL is unable to guarantee a confidential relationship between themselves and a child, because that's basically the direct representation model that we were talking about before, where a child directly instructs a solicitor. However, they're expected to strive to build trust and respect, and they should explain their role, including how the child can have their say and make their wishes known, that if possible, where a child with sufficient maturity wishes to have direct representation, so that's what I was talking about before, direct representation, how the child can contact the ICL, and the involvement of the family consultant to write a family report, including the nature and purpose of that report. So in terms of unable to guarantee confidentiality, that's examples there would be that if a child made a disclosure, something along the lines of, I don't want my parents to know that I said that, well, the ICL can't guarantee that it won't somehow come out. And it's ultimately for the ICL to make that call. But obviously, like any lawyer, counsellor or psychologist dealing with children, if the child does make an allegation of abuse, then they have to refer the matter to the appropriate child protection authority and assess the child's safety. As food for thought, perhaps there is a conflict for the lawyer representing a child. So if a lawyer was considering taking on a child, maybe one of the issues for them is if a child did make a disclosure, and it may be that the child says, no, you can't tell anyone that I told you that, but they may not even know whether they're in danger or not. And so you can see that there's that tension that comes when you're trying to represent children, or if you were considering representing children. So let's just turn to the role of a family report. In practice, it is the primary tool for bringing children's wishes before a court in an admissible format. A court can order that parties participate in a family report, including making their children available by bringing them to the session. So an interview is usually conducted by the family consultant, and then they write the report. A court can order a family report to be undertaken of its own motion or by application of the ICL or one of the parties to the proceeding. It's not uncommon in disputes about parenting for there to be only an order about a family report being done rather than an ICL and a family report. So most cases concerning parenting matters that come before the court will require a family report to be undertaken. And an appointment of an ICL is usually only for the more extreme cases where there's really intractable conflict and a significant allegations of abuse. So it's got to be that little bit higher before an ICL would be appointed. But in most cases, a family report will be undertaken. The family court may direct a family consultant to give a report on such matters as it considers are relevant or desirable to the dispute. Unless the child is an infant, so 0 to 2, and can't communicate for some reason, so or if there's special circumstances where the child is unable to communicate, they're the only reasons why the views might not be canvassed. But if they can communicate, a family consultant must, and it's important that it is in legislation that they must ascertain the views of the child in relation to the matter and include those views in their report. Again, though, that's all caveated by a family consultant cannot force a child to give a view. And often you'll see that in a family report. I've seen it a number of times where a child will just, not interested, won't engage at all. And there really can be little that can be said about the views. It's more just an observation in those circumstances. Let's just talk briefly about the influence of a family report. The Australian Law Reform Commission did a seen and heard priority for children in legal proceedings. It's Report 84. And that was published back in '97, so it's quite old now, but it was interesting. We've implemented many of those recommendations, but there was some statistics in there that family reports are prepared in 60% of contested cases involving children that proceeded to trial, and family reports are highly influential and prompted settlement and was followed by 76% of judges in which they were prepared. Unfortunately, just on my research, there was no recent statistics which looked at the same parameters, but look, anecdotally, I would say that continues to be on the rise, and I would say that they remain highly influential in the judge's decision-making process. I would certainly always advise clients that the family report interviews are a very important part of the litigation, and in all likelihood will significantly influence the judge. The family consultant makes recommendations, and look, the judge isn't bound to follow those recommendations, but certainly they have to take those recommendations and insights into consideration. And the short of it is that most of them, will follow it to some degree. There's some judges that won't, that there might be some good reason for not doing it, but in most circumstances it's followed reasonably closely. Now we come to what weight is applied to child's wishes. The answer there is it just really depends. In considering a child's wishes, these are the sorts of things that a judge or an ICL or a family consultant will turn their minds to. So they'll look at the degree of emotional and intellectual maturity of the child, the apparent strength of those wishes, does their wishes have a sound and rational base, and what is influencing the child's wishes, if anything, and is it wholly or partly due to manipulation by a parent or other significant person in the child's life. Now, I'd suggest to you, look, these things are something that I would normally turn my mind to as well when an issue like this is raised about children's wishes, and I'd be reality testing with my clients about what they're saying about the children. One of the things that you know, you can reality test about is obviously how aware the child is and what the, you know, what's surrounding these issues. The apparent strength of the wishes. How many people are the children telling that they want this change to occur, or they don't, you know, that these are their wishes? Sometimes you'll have cases where children will be running away from one parent, which is obviously a fairly strong indication that there's something going on and their wishes may not be being heard. The other things to think about is, what is the likely impact on the child if the wishes are given significant weight? What is the likely impact if they're not given significant weight? And where there's one child, are there any competing or divergent wishes amongst the children? So we're really looking at that impact of siblings, and sometimes there's consideration given to whether siblings should be separated, which, look, as a rule of thumb, most courts would be against separating siblings. That's generally not considered in their best interest, but it's certainly an issue where you've got a lot of that you could have competing wishes, and that's got to be considered. Children's wishes, whilst they are important and can have a significant impact on the outcome of proceedings, it's one of many factors which the judge has to consider. Ultimately, the weight to apply to a child's wishes is at the discretion of the judge hearing the matter. The judge is not obligated to make orders consistent with a child's stated wishes. Rather, they are obligated to consider the weight to be given to those stated wishes. So it's really a very discretionary thing on the part of the judge. Now that brings us to relocation, and relocation in the context of children's wishes. Relocation matters are not a separate sub-branch of matters given special consideration, so they're not. You won't find relocation referred to in the Family Law Act. It's really just a term adopted by people in the profession, or family lawyers in the profession, to describe a really common situation where simply one parent is seeking to take the child a considerable distance from the other parent. So they're moving interstate, and it might be, or internationally, or even within the state. Queensland's a very big state, so it can disrupt the other parent's time if they move even within the state. And usually they are for very legitimate reasons. It might be a new job, a new relationship. Look, what I would say is they're very commonplace now, relocations. When I first started practicing, it was fairly uncommon actually. You didn't see it that much. But it's now really an everyday occurrence. We move around so much these days. What I would say is that it really just, what relocations do is that it really has it doesn't change how the judges look at things. So they'll still look at a child and what their wishes are. They may wish to move with the parent, they may not, and a child's wishes will be considered in exactly the same way. But the practical reality is that relocation just tends to really intensify things. So any issues that are there will be more intense because relocating obviously has a big impact on the parents and the children. We had a matter a number of years ago now where we represented a mother of a 14 or 15-year-old boy, and by agreement that boy had lived predominantly with his father but had spent regular time with mum, including holiday time. And mum was living, I think it was in, she wasn't living close to dad, but she would spend, the child would spend regular time with mum and holiday time. And one holiday time, I think he had decided that he really wanted to live with mum. The problem for mum was that she was about to move to Western Australia and she was starting a new job and she had a new husband over there. And she had to start on a certain date, so she couldn't stay in Brisbane. She had to leave. And the child, I think we'd been through a mediation and the child had really been voicing strongly that he didn't want to live with Dad anymore. And my understanding that there was nothing really wrong with Dad. He was a little bit regimental, and Mum was more relaxed. But the child, for whatever reason, had decided that he wanted to live with Mum, and it wasn't working. And so the child was even running away, and the client was quite distressed, I remember, and she was saying, well, look, you know, what do I do? I've got to go. The child's running away from home all the time. He doesn't want to stay with Dad. Dad doesn't seem to be listening. Negotiations have broken down. Now, we'd advised the client that the appropriate course of action was to make an application in court to change what was happening so that the child would live with her. But she had to go, and so she went against our advice and she took the child with her. Now, Dad, quick smart, got a recovery order, on an urgent recovery order listed, and on an interim, the child was actually, even though the child was, I think, going on 15, he was actually ordered to return. So the child had to return and live with Dad in Brisbane until the final hearing. Luckily enough, we did have a family consultant appointed fairly quickly, and a family report was done. And the family report writer's recommendations in this case was that the child be allowed to go. And in the end, I think it was on the day of trial, they did agree that the child could go. So there was a happy ending in the end, but it just was a very stressful situation, and stressful for all parties concerned. We'll now just take a moment to look at some recent decisions dealing with children's issues. There's this recent case of Bondamonte and Bondamonte. This is a High Court decision. Now this gets family lawyers very excited when we get a High Court decision, because it doesn't happen all the time. I would say we only get a High Court decision dealing with family law matters probably every couple of years. So when one does hit, we sort of take a lot of notice. This case involved parties who separated in 2010. There were 3 children who at the time of the hearing were 17 and 15. They were both boys, and then there was a 12-year-old girl. At the time of separation, the children lived with the mother and spent time with the father, and the parenting arrangements were resolved by consent in June of 2015. And the orders were that the parents had equal shared parental responsibility, which means that they were supposed to consult on all major long-term decisions for their child, so where they live and those sorts of things. And they also agreed that the parents were permitted to take the children on an overseas holiday. In December of 2014, so about 6 months later, the mother filed a fresh application in the family court, and at that time the 2 boys were living with their father, so that's important. The eldest boy had been estranged from the mother and was spending no time with her, while the middle boy continued to spend time with her, so regular time, and the little girl lived with the mother and continued to spend time with the father. In January 2016, the father gave notice to the mother that he wished to take the boys on an overseas holiday to New York. Now, the mother initially resisted the holiday, but she did ultimately consent. Shortly before the boys' scheduled return, the father advised the mother that he intended to stay in the US indefinitely and that the boys wished to stay with him. The mother then urgently filed an application for the boys' immediate return. Now, the story goes that she also filed a Hague Convention application because, as you might be aware, the US is a Hague Convention country. But the problem was that it only applied to the middle boy, because the other child, who I think was almost 17 or was almost 18, was too old to be captured by the jurisdiction of the Hague. So she basically filed both in the family court, and she also filed for Hague proceedings as well. So she did both. Um, I've just recounted there a text of the letter which appeared in the judgment of what the father's solicitor sent to the mother's solicitor, and I just want you to take a little opportunity there to have a read of that. Um, I've highlighted the bit that I think is most interesting, and where they've sort of, you can see that the solicitor has really picked up on the idea of the children's ages and their maturity. And it says, we note, given the children's ages, who were 16 and 14 at the time of writing this, the children are likely to object to any attempt to return them to Australia, taking account of their apparent strength of feelings and their respective degree of maturity. So that brings us to polling question 2. So before I tell you what happens, what do you think the outcome of this matter was? And so you'll see that there's 2 options here, that the children were ordered to return to Australia, or the children could stay with Dad in the US. So if you could just take a moment, please, to vote which way you think it went. Okay. So just going on. So at the decision of the full court of the family court upheld the decision of the judge in the lower court, which was that the boys be returned to Australia. If the father refused to return and the boys did not wish to live with their mother, remembering the eldest had been estranged and hadn't been living with mum at all, or hadn't been seeing mum at all, they could live at either the parents of respective friends of the boys, or they could live in a supervised accommodation paid by the father. That in itself was very unusual. The father then applied and was granted special leave to appeal to the High Court. So you can't just automatically appeal to the High Court. First of all, you have to have special leave to appeal. So the High Court found that the father's main point of appeal was that the trial judge, supported by the full court, had failed to pay proper attention to express views of the boys to remain in New York with their father, and refused to give their father an adjournment to allow for a wishes report to be undertaken in New York. Now, the High Court said to that point that the father was making, this main point, that the children's wishes were really uncontentious. Everybody knew that the children wanted to live in New York, and that really wasn't the issue. The issue was the weight to be given to those views. The evidence before the court suggested that the father was a man of significant financial means, and he had, perhaps tellingly, I would suggest, flown the boys first in business class over to New York, but had only booked economy class back home. There was evidence that the boys were really enjoying New York. They had settled into a new routine, school and friends. They had a great lifestyle over there. The High Court noted that the father had a tendency to elevate the boys' views to a level of decision makers, and whilst the court accepted that the boys did indeed have an expressed desire to remain living in New York with the father, there were many other factors that the boys hadn't turned their minds to. The main one being separation from their mother and, of course, their little sister. I always felt that the poor little sister got missed out in this matter. The High Court strongly criticised the father for his flagrant disregard of the orders, remembering there were orders in place where both parents had equal shared parental responsibility, and chastised and stated that the lower courts did not miscarry because they considered the views of the boys and then discounted them, remembering that a judge only has to consider the views, it doesn't have to follow the views. Especially in circumstances where the father had encouraged or engaged in conduct which impacted the boys' views in a negative way and bolstered their desire to remain with him. What's interesting about this is that apparently the father had remained silent about whether or not he would return with the boys, sort of giving the indication that he didn't intend to return with the boys. So he really made it feel like it was dad versus mum. that it was Australia versus the United States, and there really wasn't another option for the boys. But in reality, we were only in interim proceedings, which meant that there was still the family report to come, there was still final hearings and those sorts of things to happen. So it certainly wasn't an open and shut case, or as this way or that way as the father appeared to be presenting it to the children. Unfortunately, I don't know what actually happened ultimately with that case, whether the boys did in fact return. I did hear that the High Court deliberately brought their judgment back quickly because the eldest boy was about to turn 18, and if the eldest boy had turned 18, then of course their judgment would have been all academic anyway. So that's just interesting, that because usually the High Court would take a number of months to come back, but they had a very quick turnaround in this particular matter. I'll just take you now to another decision which deals with children's issues, and that's the decision of Boyce and Boyce. There was 3 children in this, aged 18, 17 and 13 at the time of the hearing. The father was complaining that the mother and her new husband had estranged the 17 and 13-year-old child from him, so alienated him and all those sorts of things, whereas the mother was saying, look, I'm just following the children's wishes. The 13-year-old girl, so the youngest in that case, had profound deafness, and apparently she was resisting spending time with the father. At the time of the hearing, she'd in fact hadn't spent any time with the father for a period of about 10 months, so it was a fairly significant amount of time. The family consultant in that case had formed the view that the mother and her new husband had in fact not been encouraging the child's relationship with the father. The child had consistently articulated a view that she didn't wish to spend time with her father, although it was also noted that she did not appear to fully comprehend what her views meant. It was also noted that by the judge that the mother had willfully disobeyed court orders when she withheld the child from school deliberately so the father could not collect the child. So you'll see that that was reflected in the High Court. Obviously the courts don't like it when parents don't follow the orders. So she was certainly criticised for that, and particularly in circumstances where this child had profound deafness, and obviously school and learning would have been that much more difficult for the child. It was found in that case that given the child's lack of emotional intelligence and maturity, and given her expressed views were given little weight, and orders were made that she still had to spend regular time with Dad, even though she didn't want to. So what about older children? So this case does deal with older children. It briefly says in this judgment, and we know this as well, that the court has no jurisdiction over adult children. It was accepted that the 17-year-old would make her own arrangements with regards to time with her father. So that you just have a bit of an understanding of what sort of orders can be made in relation to older children. This is what, I'm just going to read an extract from that judgment. It refers to, it doesn't give the children a name, it just says X. X's age being 17 means he can manage his own relationship with his father. This is a circumstance that has existed for a long time and is the only viable order that has any prospect of implementation. Given X's age, his wishes are determinative of the outcome. So the example of the order given there for the older children was this: the child X shall spend such time with the father as arranged between X and the father. Or another one that I commonly see is something along the lines of, and that there be no orders as to X. So older children are sort of treated like that. It's just interesting to note that this decision predates the High Court decision, so the one that we've just gone through. So I would suggest to you that in the current climate, I don't think that there would be such liberal comments made. You know, that's a fairly liberal comment about saying that the child's wishes were really determinative of the outcome. I think you'd find now that the judges would be more conservative given the High Court decision, even though practically it might still have the same impact. The final decision that I'm just going to quickly run through with you is a very recent decision. This is only an interim matter, so it means that it's still going on in the courts. It's the matter of Beckworth and Garnett. There are three children in this case. Eldest child is a girl, lives with mother. Middle child, a boy, lives with the father. And both parents had agreed right at the outset that that should remain the same. The dispute was really over the 10-year-old girl who had predominantly lived with dad but wanted to move across to the mother's household. All three children at the time of separation had lived with the father by consent, and the father had made an application for recovery of the two girls who had been withheld by the mother on a contact visit. The youngest in that case had been ordered to return, and so there was then an interim hearing about what should happen. The issue was what weight to give the 10-year-old girls on an interim hearing. The court found that the mother had been disingenuous in regards to her proposal that the 10-year-old spend time with the father as agreed, as clearly this was a high conflict case and they were never going to agree. Interestingly, in this case, both the ICL, so the independent children's lawyer who had been appointed, and the mother attempted to persuade the court the child should remain with the mother in the interim, seeking that the court accept the child's expressed views as reflective in the evidence. The father argued a more cautious approach. The court had to consider the weight to be attached. There was evidence before the court that the child had said at school, look, things are more fun at mum's, but what was absent was the child saying that making any complaint about the father's household. So there was no real suggestion that the child was unhappy in the father's household. On the other hand, the mother had made significant complaints about the father, which the court felt was a gross exaggeration given her complaints were inconsistent with her actions, and she tended to lack insight into her own behaviours and the effect that they may have on the child. Extraordinarily in this case, the two daughters, so the eldest daughter and the youngest daughter, the subject of these proceedings, had been interviewed by mum's legal representative. So mum's lawyer and mum's counsel actually interviewed the child, which I can tell you is quite extraordinary and certainly shouldn't happen because for all sorts of reasons. So that brings us close to the end. What I wanted to just go through now was, look, children's wishes are important, but it's not the whole picture. There is no set age until they are 18 where a child can choose with whom they live. So that's the answer really to the first polling question, it's 18. Although an older child can clearly express wishes and insight into the impact of those wishes, so if they can clearly express those wishes, if they've had them for a long time, if they've got insight into what that might mean, repercussions of those wishes, then more than likely that is going to be given some weight. And if not, eventually the child will probably vote with their feet. Interestingly, when I attended that ICL workshop, one of the things that came out in the social science research was that younger children tend to stay with the primary carer, so the parent that's looked after them sort of from birth, while older children tended to gravitate to the household with the most resources. So that's interesting. So what that means is obviously teenagers probably tend to go to the parent that's you know, supplying the most iPads and computers, and probably, you know, because what happens then is that the child, obviously from a developmental point of view, is maybe more primary attached or having social relationships more, so those things become more and more important as they get older. Sometimes resisting change does more harm than good, and this is something that I sometimes have to talk to clients about. It's better sometimes to let go rather than holding on at all costs, because ultimately the price that parent might pay is their ongoing relationship with the child. I try to encourage clients that find themselves in that situation to try to negotiate a good set of contact orders instead. often the complaint, and quite legitimately so, is, look, I've done all the hard yards with this child, I've changed all the nappies and done all the routine, done all the discipline, while the other parent's been the Disneyland dad or the Disneyland mother. And I say to them, well, let the child go, and the kids can discover for themselves. And some parents will step up, so the other parent will sometimes step up and look after the child well, and it's all a win-win. But sometimes they fail miserably, and you'll find that the child comes back to mum or dad, as the case may be. One thing that I also say to parents is, look, often kids don't have a real appreciation for their parents until they're much older, and they're either parents themselves or they've involved in the care of children and all that entails. One of the take-home points is that not all children have a clearly defined view, and whilst almost all children wish to be heard, they often do not want the pressure or responsibility to make the decision, or to be put in a situation where they have to choose. Look, I think that's a fact that unfortunately too many parents fail to understand, and it's part of our job to sort of enlighten them about those sorts of things. Okay, so that basically ends our topic and our talk today. I want to take the time to say thank you for spending some time with us today. If you want to know more, just let us know. You can contact our firm and we can send you some more information, or we can even meet with you. We will just let you know that we do have a fixed fee first consultation of $330, including GST. That just allows people to come and see us with no obligation, so they can come and see us for a first appointment for about an hour or so, and they can decide whether or not they go further. It's up to them. So thank you again, and have a great afternoon.